Now, we mentioned that criminal law is not the number one focus. We wanted you to have a basic understanding. On the other hand, tort law is a very, very important aspect to business practice. We need to be aware of what our liabilities are. Most of the time it's going to be a tort. Tort is simple. It's just the word for a civil wrong. So that's why we call it tort law. In law school there's 2-3 courses just on torts because it's such a big deal. And we're going to touch on just a few of the key concepts within tort. Generally speaking, we're seeking money damages, although sometimes we're also seeking injunction to prevent people from doing things. What we do want you to take away from this chapter is the definition of damages. So compensatory damages are the most straightforward. This is to get you back to where you were. What kind of loss did you have? You were in a car accident. You can't go to work. So you lost income. That's compensatory damages. You were taken to the hospital. The hospital doesn't charge the other side. The bill, they send the bill to you, $250,000 bill for the emergency room and a couple weeks of hospitalization. You get to pay that bill, or your auto insurer does that. They're going to subrogate. They're going to come behind your right to collect that money, and if you don't have insurance and you can't pay it, the hospital will go and subrogate under your claim to go against the tortfeasor, as we say, the person who committed the tort. And one of our big issues there is to find the deep pocket. Who's the deep pocket?
Insurance company.
You business people, because you guys have big insurance. Yeah, a bunch of those people out there either have no insurance or they're 2040s. Your business insurance is in the millions of dollars. So you're going to sit. It's like Ghostbusters, you know. You're going to get. You're going to get the people with the deep pockets, and the deep pockets because they have most insurance and they also have money, which is why they have insurance to protect the money. Punitive damages. These are very controversial. This is to punish you beyond compensatory damages. In Texas, we have had tort reform. Tort reform has basically dealt with this by saying if you have a certain amount of compensatory damages, the amount of punitive damages on top can only be a certain percentage of that. So you can't have a $20,000 loss and have $2 million in punitive damages. It doesn't work. So there has to be a proportion between the two by Texas tort law and what we call tort reform.
And that's mostly related to malpractice, isn't it? And what is the big
you can have it in all places. It's very routine to allege punitive damage or allege a claim for punitive damages to say, well, if you've been driving more carefully, or to go against the company and said, if you had really checked out John, the driver's record, you would have seen that he's had 3 convictions for DWI, therefore we should punish you. So even though we only had a minor loss of income or medical bills, well, we want to really sock it to you, so we want $5 million to show the public that you guys are really sloppy and you should have been more careful. So no, but that's where you hear that argument, and so, but the problem with that is it's like hitting the lottery. Except who pays that money? You think the insurance company loses that money? Well, I haven't seen too many insurance companies losing money except under Obamacare. I mean, insurance companies generally don't lose money. So, yeah. So, in fact, I was just reading an article last week talking specifically about trucking companies, saying trucking companies are really taking it, saying, ironically, there are fewer accidents. We're driving more safely. The trucks are better built. Cars are better built. But they've had a few gigantic awards, and it throws the whole thing off. And they're saying the trucking industry is going through some hard times because they can't raise trucking rates to match up with how fast their insurance is going up. And here in Houston, we all live with very high insurance rates because it's such a crapshoot every time you're on the highway here. And there's so many uninsured drivers, even though it's technically against the law to drive uninsured, the reality is there's a lot on our streets. So, a lot of stuff going on. Now, I'm going to introduce you to a term here I want you to remember through the course. Respondeat superior ought to be in italics. It's an Italian term. It's a Latin term, and it means the boss is always liable. Is that the owner of the business, the responsible party is responsible for their employees, their servants, literally servants. Respondeat superior. So keep that in mind. We're going to see that again in the employment chapters. Keep in mind, if there's multiple people involved in an accident, you can be jointly and severally liable. The reason that's scary is you might have only been a minor part of the accident, but the court finds you and the other person responsible. The other person doesn't have any money or doesn't have any insurance. Guess who's going to pay the whole bill? Yeah. Yep. So that's why it's a scary concept.
Excuse me.
Yes, sir.
So, I mean, this is really, it's like an example, but I have a question about the liable persons here. So my brother-in-law was recently, he gave permission to his roommate to drive, that he could drive his car before his roommate was intoxicated, hours before.
Okay.
The roommate took the car, crashed it, got a DWI, went to jail. Now the insurance company is saying that technically it's his fault because he gave his roommate permission to drive the car before he was intoxicated. So they raised his rates and not the rate of the guy that actually crashed the vehicle.
Well, the guy who actually crashed the vehicle will probably become uninsurable. They don't have to worry about his rates. He probably won't be able to get insurance except.
So why did the rates of my brother-in-law go up?
Because insurance companies pretty much do whatever they want to do. Do I think what happened is fair? No, but it's not about fair. The insurance companies operate pretty independently, and unfortunately, if you look at the path of about 90 years from Justice Cardozo in New York around 1920s, 1930s to the present, the liability for businesses and individuals who are responsible has skyrocketed. So whereas if that case happened 80, 90 years ago, your brother-in-law would not have been held responsible. Today, it's almost automatic. And again, it's a search for the deep pocket, it's a search for the insurance. And I tell you, nothing scares me more than to loan a vehicle. And I have a van. I have an old van parked in my driveway, and I drive about 1,500 miles a year, and I do get periodic requests to borrow my van, and I'm just petrified to loan a vehicle, even the very responsible people. Like the only person other than myself and an auto mechanic who's driven my van in the last 20 years is my son. So the only person I trust to actually drive the vehicle, I was petrified while he was driving. But and he's a real safety nut himself. He's actually a safety engineer. So so I felt reasonably safe. But yeah, it's unfortunate but true. And this is respondeat superior, talking about in business. Anything bad happens, they're going to do a forensic analysis of the person who was working for you to say, did you do a comprehensive analysis? Did you really check this person out before you let them behind the vehicle? The grill of the vehicle, and it's just tough, and that's why we teach courses like this, because we want you as business people to realize how much pressure is on you. So you need to have good insurance, you need to have very good protocols, and I mean, I think hiring people today, you really have to get in there and get after them. I mean, it's really a big deal. It's nothing easy. We talked about liable persons. We talked about it in the criminal actions chapter. We come back to the civil chapter. So basically, in civil situations and torts, is children under 7 presumptively unable. Parents will probably get tagged up on that one. They use the 10-year benchmark. Again, it's going to depend on the crime and the nature of circumstances. Generally speaking, if they're, even 14, 15, 16, I think it's going to take some doing before you make people even that old, if you will, to be responsible. But they're going to be out looking at the parents to say that the parents put something in place. One of the classic examples happened here in Houston during the last holiday season is that they had a big drug party at this house, and the mom was there. So, you know, they're doing drugs and all sorts of bad stuff was happening. So the mom got arrested for contributing to delinquency of a minor and drug dealing and all this stuff. And, you know, kids got arrested for possession and stuff. But it was really an underage drinking, but it was really wild situation. But sometimes you do hear the stories like movie Risky Business where the parents are out of town and the kids, you know, get into things. A lot of times the parents are held responsible because they set up a scenario where something like that could happen. So, something to watch out for. Intentional torts, a little bit different. This is where you intended to cause the harm. Most of us do not take our car and run into another car. On the other hand, there may be days. Probably the most famous example of this was the, everybody remember out in Clear Lake, I don't know how if everybody's old enough to remember this. The Clear Lake, I see some people nodding their head. Okay, scenario is husband and wife are both dentists. And the husband is having an affair at the Clear Lake Hilton down off NASA 1. And in the parking lot, she figures out where he is. He comes out of the hotel from a little tryst with his friend. And she takes her Mercedes and runs him over. Then she backs over him, make sure he's done good. So of course he's killed, and she's prosecuted for you know, first-degree murder because she plotted it and intended to do it. Even though there's some people in this room who might maintain it was justifiable homicide. So, I don't know how long she got in jail, but it was a very, very high-profile case. And had a lot. But anyway, that's an intentional tort. You intend to do it. So it's a criminal act, but it's also an intentional tort. Now, if she was doing it as a business, if she was employed by a business at that time that did the action, then you might say, well, we could never anticipate that someone would take our vehicle and run over somebody on purpose because they saw their ex-spouse, you know, or soon-to-be ex-spouse wandering in front of them. Stuff like that. So a lot depends on that. Generally speaking, intentional torts, unless you set up a scenario where somebody has done other crimes like this and you didn't bother to check out their background, then you're probably going to be okay. They're probably not going to be out there. Remember we mentioned that term prima facie in the last chapter? Prima facie, again, just means articulating the elements of the tort. And so we're looking at unprivileged conduct. You have to have prima facie case to go to court. Unprivileged, this would be remember one of the things that we like to use as an example of assault and battery. So if you don't have to be, they're two separate offenses. Assault is to cause someone to be in fear. They don't have to be touched. That's assault, is to put someone in fear. So I hold my fist up like this. It's not assault because he knows I'm not going to touch him. But if he was really concerned I was going to touch him, that would be assault. Now, if I take his arm, that may not be battery. But if he doesn't want me to take his arm and I touch him, even if I don't hurt him, that's battery because it's the unprivileged touching that is battery. It doesn't mean hurt. So a lot of times we think about assault and battery a little bit differently than it is. We also always say it as a pair because generally speaking, if you get hit, there was a moment of apprehension before somebody actually connects with you. But it's pretty important, and I do some training for other faculty and stuff, and we encourage faculty not to have a lot of physical contact with students because of that, because sometimes it can be misunderstood. And that's what we do. It's not because people are trying to be unfriendly, it's because it can be misunderstood and can cause some legal issues. So we try and make it reasonable. One of the things is shopkeeper privilege, and this extends to arrest for shoplifting and stuff like that. The big loser in one of these cases, Kmart. So if you look up Kmart in a shoplifting, they lost one of the big cases. Part of it is you pick up somebody who's shoplifting, they sure need to have something in their possession that wasn't paid for, and all that. But you hear such wild stories. My favorite was at Walmart a couple years ago. Somebody put on a little blue vest, walked one of those big screen TVs right out of the store onto the dollar. Just a little blue vest. Still a crime, it's just kind of funny. One of the things I want to mention that we hear a lot about is mental distress. Many times when a tort suit is filed, people allege mental distress. Well, in Texas, in the crime, not crime, but the tort is IIED, intentional infliction of emotional distress. So I not only defamed you, but I wanted you to feel bad. So the act was defamation. Now in Texas, it's a little bit different. In many states, you can just say, you did something, you made me feel bad, so in addition to going after you for this, I'm going to come after you for IIED. But the issue is, in Texas, you actually have to have an injury. It doesn't have to be a real serious injury, but you have to have a physical injury in order to allege mental distress. So a little bit different, a little higher standard in Texas than in some other states. And of course that helps us as business people, but again, it is very common to allege emotional distress in a variety of cases. Keep in mind, you've got a lot of routine claims. Trespass, obviously, is going on somebody else's property or in some way violating somebody's property rights. Conversion is the polite term for stealing. Criminal act is stealing. Civil act is conversion. And nuisance. Nuisance can be, North Carolina, sadly, they've had a lot of pigs and chickens that drowned in the horrible flooding in North Carolina, a big produce state. But one of the things that happens is if you're next to a pig farms generally smell bad, by the way. They just smell bad. It's hard to control that. And so if you're on land next to that, you can allege nuisance because it makes your property less valuable even if they don't come onto your property. So sometimes that's viewed as a trespass offense, but it can also just be argued as a nuisance. You, by your acts, have made my property less valuable. Disparagement, we see this a lot. Probably the best recent case is Papa John's and Domino's went at it. The case was eventually dismissed, but the allegation was that Domino's sued saying that Papa John's indicated that they were the only ones using real cheese, and Domino's said our fake cheese is as good as anybody else's real cheese or something like that. So in any event, yeah, it's an interesting thing, but that's disparagement. You can't say bad things about other things. And keep in mind, there's some prosecution for that. There is trade examples of that in a variety of circumstances where you have situations of disparagement. Federal Trade Commission can get involved in those cases. So if you say our product does this, you better be prepared to prove that your product does that. And I'll tell you what recently somebody really got hammered on this. POM, P-O-M, the pomegranate juice, they allegedly said, well, we make a fabulous thing. You should drink this every day because you'll live to be 212 and all this stuff. And the Federal Trade Commission stepped in and said, prove it. And of course, there's no lab test that proved anybody will live to 212. And so I'm just exaggerating. I'm just saying, apparently they were making health claims for because it is supposedly a high oxidant product. So they weren't very happy about that. And all that.